It's in the filing. And we then wrote an email. There was an email from my assistant again.
So your submission is that actually you suggested certain timing for this meeting and the prosecution was not able to. Thank you very much, Mr. Attorney General. But my understanding is that in submission is that this meeting has nothing to do with this case. Am I correct?
Your Honor, is correct.
That is the heart of the problem. The person claiming that the meeting we were to have was about something else is the person who have that conversation as to what we were meeting. I am here to speak for myself, that I called a certain person who I have named by name, told, let us meet and advance the discussion. That person is not saying that that conversation didn't happen. Some other third party is saying that that conversation didn't take place. I wrote an email, my assistant wrote an email asking for a meeting to discuss this matter. That email was not responded to, and I don't hear it being said now that the email was never written. Be that as it may, what then followed was a process through which we were communicating in writing, almost on a daily basis, or every 2 days. And I was saying, now find here enclosed what I have received from the National Security Service, etc., etc. I consider that to be a continuing consultation.
Thank you very much. Another question, Mr. Attorney General, about the current status of the cooperation and the way forward. In your most recent filing, Mr. Attorney General, that is the observation you provided on the prosecution's update, you indicated that the reason why some of the materials sought in the revised cooperation request remains outstanding is, Attorney General, that is the observation you provided on the prosecution's update. You
That is our case, Madam President. It is the case we informed the court the first day we came here. It was the case we informed the court the second day we came here. We are informing the court again today. We have noted it at great length. Allow me, Madam, briefly to talk about the land records. We have set out, we have given my learned colleague all Kenya relating to land and all the forms that anybody, including the Kenya government, must fill in order to get a report relating to titles. We have begged this court before, and we do so again.
I think the chamber has all information about those conditions.
Point, please, Madam, because I need to answer you. It is true. Unless the prosecution is able to tell us we are interested in land reference, please get us a search on that title. And I have promised you, if that happens, we will bring the search within 72 hours. We have also said, if you know of a motor vehicle by its registration, and you give me the number, I will bring the logbook that tells us who owes that number, and I will do it in 72 hours. If you have a telephone number, we will be able, post 2009, to ask the providers to give us the name and the logs of the telephone. If you have a telephone number, we will be able owns which trust, you have to give it. And within 72 hours, we will. Unless the prosecution, Madam President, takes itself more seriously on this matter, we are put in a difficult and impossible situation. Because we are being asked, you machinery of state, to find out something that the law has created a procedure for.
Mr. Attorney General, but as you said, for example, that you say in order to provide the prosecution with necessary information about telephone communication, your government needs, for example, a personal identification number issued by the Kenyan Revenue Authority. Do you really consider that to be a reasonable position?
Absolutely.
For the government to take, that the prosecution must provide a PIN issued by your own domestic revenue authority?
Because, Madam President, this is the requirement of the law to be able to conduct a land registry search or a company registry search. You must have the name of the company, the name of
Mr. Attorney General, my example is personal identification number issued by Kenyan Revenue Authority.
It is not the personal identification number that facilitates the entire search. The personal identification number is a number that you provide the register. It is not the personal identification number that facilitates the identification number of Mr. Uhuru Kenyatta. This is something to be supplied to the registrar. Unless an argument is being made that the government has a surveillance system where every person's identification number, the equivalent of a social security number, is available willy-nilly. It is not. This is information, and I want, Madam President, that you should allow me to make this point one more time.
I don't think you need to repeat.
Request.
Mr.
The
Attorney
request
General.
is not for me to
Mr. Attorney General.
Madam President.
I think I don't want you to repeat anything. And just my apology, I get confused. This PIN is something
Social
for
security
the,
number.
yes,
Yes.
something for land records rather than telephone records.
No. It is a number. May I explain that, please?
No, I don't think you need to explain.
Very
I now
well.
fully understood.
Very well.
Prosecution. I would now like to return to you on this point. Could you please comment on the Kenyan government submission about this further information, the necessity of further information from you in order to execute the cooperation request?
I can. And I think I can best do it by giving an example. And the example is the telephone request. In the course of gathering information, 2 prosecution witnesses, and the example is the telephone request. 2 prosecution witnesses and a number of other people has spoken, or from whom we have been provided with statements, have suggested that at relevant time Mr. Kenyatta's telephone number, which ended in the numbers 891. collaboration with the defence, we have caused inquiries to be made into that number, and we have received some. Sadly, those records are very partial. Relating to the relevant period, we only have records of telephone calls which were made to that number, not records of telephone calls which were made by that number. So we've got incoming, not outgoing. Furthermore, over the period of December 2007 and January 2008, that telephone number, if it was Mr. Kenyatta's, as we are informed it was only in contact with 5 other numbers. Thus, we confidently assume that the records we have do not represent the entirety of Mr. Kenyatta's telephone contacts at that time. We don't have access to any other number which is said to have been Mr. Kenyatta's at the time. And therefore, we are not in a position to give the Attorney General what he says he wants, because we don't have that information. It is indeed the information which we are seeking from the Kenyan government. We suggest that the idea that the Kenyan government doesn't have records of telephones being used by cabinet ministers, as Mr. Kenyatta was at the relevant time, is an unrealistic information which we are seeking from the Kenyan government. We suggest that the idea that the Kenyan government doesn't have those numbers to us and to the telephone service providers, and there would be at least the hope that we would receive records as those which we have received in respect of the 891 number to which I have referred. But it is simply a circular argument for the Attorney General to say, I can only give you the records if you give me the telephone numbers, because it's the telephone numbers which we are asking for. He knows that that is material which we say the Kenyan government must have. We're asking them to provide to us as a springboard for other material. That is an answer in respect of just one of the 8 heads of inquiries that we have made. But I hope that it illuminates all 8.
Madam President,
Thank you very much. Mr. Attorney General.
May I have your permission very briefly to respond to that? Because this is in fact the heart of the problem before this court. We have an investigation that has taken place for 5 years. We have an investigation team and a prosecutor who has come to you repeatedly and said, we are ready to proceed with the case because we have evidence. What Kenya is supposed to do is to cooperate to facilitate in confirmation of the availability of material. What the prosecutor has just admitted to is that they have never known, have never had access to what they said in their speech here before you. In his speech before you, he said, we have critical information. Critical information is that they have never known, have never had access to what they said in their of phones used by cabinet ministers. There is no offer of evidence that Mr. Kenyatta's phone was a phone assigned. This is the sort of circumlocucious argumentation that we have done, we have heard, that we are saying to you is not useful. And I want to repeat this, Madam President. The only reason the prosecutor caught that he knew of telephone numbers belonging to Mr. Kenyatta is because we came and told you, Madam President, that Mr. K, as a defense lawyer, and the prosecutor, behind our back, and they were not supposed to tell us, had gone to court.
Mr. Attorney General, I'm sorry to say that you are again start
Okay,
repeating.
sorry. Let me wind up then by saying our position remains the same. All these witnesses that are referred to by the prosecutor, to whom phone calls were made, surely must have received phone calls from specific numbers. Give me those specific numbers, give me 72 hours, and I'll bring you the phone logs.
Thank you. Prosecution. In your correspondence with Kenyan government, certain explanations have been provided as to why the request for company records and land transfer records cannot, as a practical or administrative matter, be executed directly. And the Chamber understands that two records are quite important for the prosecution. Leaving aside for the moment the possibility of obtaining the information through alternative means, such as tax returns, are you satisfied with the explanations that have been provided about the practical and administrative difficulties? That is, do you consider that it is in fact necessary to resort to tax returns? Are you satisfied with the explanations that have been provided about the practical and administrative
for the organization of the company records and the land registry? They have indeed provided quite lengthy explanations as to why it is to do what I myself would have thought would be a primary purpose of keeping these records in the first place. That is to say, able to consult them to establish what land holdings, interests in companies a particular individual has. It certainly doesn't lie in my mouth of those records untruthful in the letters that they have written. I am in the position that I have effectively to accept what they say because I have no means of challenging it. If indeed it is the position that the Kenyan records of its company, the Kenyan Register of Limited Companies and the Kenyan
that the Kenyan government may be best placed to advise on alternative possibilities under the Kenyan domestic framework for obtaining requested material. And I understand from your submission so far that the Kenyan government did not advise any alternative measures for obtaining any of the information sought.
No, we have advised the prosecutor and have advised the court on the legal and administrative methods that are available in Kenya for obtaining the information he requests.
But
We have
no alternative measures
have
to
no
overcome those difficulties.
We have no extra legal or on the legal and administrative methods that are available in Kenya for obtaining the information.
Judge Freeman.
Mr. Attorney General, maybe I will have two questions concerning the last issue. Does it mean, is it my understanding, in Kenya you have accused with serious, there is a need to investigate his assets, like in this case? And does it mean that the details necessary for making further investigation on his cars, on his on land owned by him, is to ask him for further details?
Judge, the request we have received from this court and from by the prosecutor is not any different from a request we receive daily for mutual legal assistance. And a request for mutual legal assistance requires the requesting state to provide the information, the basis upon which evidence can be assembled in the receiving state. The difficulty we have in what is proposed before this court is that we are required to assume responsibility for identifying the evidence itself. I have explained before, Judge, the difficulty we have with that. In what is proposed before this court is that we are required to assume responsibility, not a party.
Thank you, it's clear to me, but take a case of your domestic investigation.
Yes.
So it's just your responsibility to be initiative. So in such a case, again, you just have to rely on consent, and I can even imagine that such accused could be even missing. But you know, you have a need to investigate. He's missing. Case you have in fact no practical chance to make any further investigation on his cars, on his lands and so on.
If in a Kenyan court a prosecutor or an investigator was to acquire evidence illegally obtained evidence, it is inadmissible in court, and it would be of no probative value. It is not a method we have used before. I would hope that I'm not being invited by the prosecutor to consider extra legal.
No. Last question, excuse me, Mr. Prosecutor, Mr. State Attorney, from my part. We also discussed this possibility of asking for approval from the accused. Have you also considered this possibility? Because hypothetically you could also ask Mr. Kenyatta whether he is willing to cooperate with you. We respect that is a right not to self-incriminate himself. If he would say, okay, I don't want, it's clear. But I also can imagine possibility that he would say, okay, I want to prove that I'm innocent, and I will provide you with those details. Have you considered this possibility?
Not only have I considered that, but in some respect, we already acted on the bank statements on that principle. And if I remember correctly, the prosecutor made heavy weather of it when we were last here. If you recall, Judge, the prosecutor was very, very unhappy. He said that the Kenya government meant on that principle. And if I remember correctly, the prosecutor made heavy weather of it when we were last speaking at the time was, it is much easier, and Mr. K, I think, will speak to this. When Mr. K and the prosecution wanted telephone records together, they went to Safaricom, they went to Airtel, they got the records. They both have them. I don't. When we wanted to have the bank records, and we were with Central Bank, with the individual banks, Mr. K himself, having had the discussion we had here, wrote to me a letter saying, and I think copied to the prosecutor, we have no objection to bank records being obtained. That is how we obtained the bank records. I hope I make myself clear, Judge.
Okay, perfectly clear. And as to the other details, because it's nice, but also there is some request for further details concerning cars and land. Is it not possible to go this way as well?
Yes, but that would not be a duty on the whole. It would be a duty of disclosure. And the record of this trial that is public shows that when in 2012 the prosecutor said they were ready to proceed, the prosecutor was reprimanded on 4 different occasions for failure to disclose. These are the disclosures. What is now being prosecuted through the back door as an application for cooperation is a breakdown in the ability of the prosecution to conduct A, proper investigations, B, to disclose mutually to the defense. We are being made sacrificial lambs about a matter that has nothing to do with the Republic and has something to do with the professional conduct of the case.
Thank you very much, Mr. Attorney General.
With the professional conduct of the case.
Thank you very much, Mr. Attorney General.
Tax returns. Mr. Attorney General, the prosecution has been requesting the provision of tax returns during the relevant time period. While the certain tax-related materials, it has not provided these requested tax returns. An explanation for not doing so, like legal or administrative difficulties. Can you please comment specifically tax returns have not been provided?
Give me a moment there. These are not foreign exchange transactions.
Tax returns.
Yes, on the 26th of August, Madam President, I received a letter which I have appended from the Kenya Revenue Authority in response to my letter of 6th August, which I mentioned earlier. And I think that the supplement, Madam President, I don't know whether you've seen it, the letter of 26th August 2014.
Is it annexed to your submission?
Yes, it is.
Can you
Can I read it for you? It's very short.
If you can just tell me annex number, that would be okay.
It's annexed to our submissions of 29th August.
Yes, and which annex?
Annex 47? No, not that one, sorry.
This one.
Yeah, we've got the letter. 29th August.
Yes, and which annex? Referring to?
6th August 24.
No, it
P 0.3. It's 13. P 30, I believe. 0 for that, Madam President. President. One. Yes.
yes. 31 is
31, 30 and 31, they are two joint letters.
yes.
The writer says, we have touched both in hard and soft copies the income tax declaration information for 2010. He explains there earlier, the information we have presents what our records contained submitted by the taxpayer. For the 2 years in question, the taxpayer filed income tax returns and paid the self-declared taxes. So that has been provided.
Yes, but the letter also mentions the taxpayer filed income tax returns, and I think that's exactly the material prosecution is seeking. Am I right, prosecution?
I think there is a slight, okay, let me be my colleague.
I have in my hand a blank Kenya Revenue Authority tax return. It is, unfortunately, familiar to many of us probably in its general form, full of boxes which have to be filled in, including space for of directorships held by the person making the return. It's the kind of information which has to be included in all these boxes which we're interested in. We don't want to know how much tax Mr. Kenyatta has paid, or how that's been calculated, which is the essence of the document we've been given. We want to know what he says about things like his directorships of companies and other financial details which this form will require him to provide. With the greatest respect to my learned friend, we couldn't possibly have been clearer that it is the completed versions of this document that we want to ships of companies and other financial details which this form will require him to provide. with the
My understanding of how this authority works, Madam President, they have explained in that letter. One, they say assessment tax regime where tax declarations which we may interrogate based on risk profile. What I understand that they do, Madam President, is that a tax form return is filled, they extract that they consider to be relevant. They retain that information which they have extracted in a format that they use for their other purposes, but they do not. That is my understanding. So that what we have been given in hard and soft copy is the income tax declaration information that is retained routinely by the authority.
So, Mr. Attorney General, what you are saying is that the Mr. Kenyatta filed income tax return,
Yes.
that kind of format which prosecution showed, but does not retain.
It doesn't retain the form. It extracts from the form. The letter is self-explanatory. The information we have provided represents what our records contain based on returns submitted by the taxpayer. For the 2 years in question, the taxpayer filed income tax return and paid self-declared taxes. That is how they work. It may not be the most efficient system in the world, but that is the system that we have.
Thank you very much. Now I would like to...
I'm very sorry to interrupt, Honor, but
Yes,
that's a
please.
piece of information which I don't believe we've had before.
Sorry, could you repeat? I didn't
Yes,
catch.
I'm sorry, I interrupted, my fault. But this is a piece of information which I believe is new. It is, in fact, further purported cooperation, but I just want to be clear. The position of the Kenyan government is that Mr. Kenyatta filed tax returns, like this one, but they have subsequently been this is a piece of information which I believe is new. It is, in fact, further purported cooperation, but I just want to be clear.
26th August it for the first time this morning, or having received it, that he didn't read it, or having read it, because it says exactly what I am saying. It says we have extracted...
Well, Mr. Attorney General, that is not so clear about the whether the revenue authority retains all those documents or not. I think that's why the prosecution is saying
We'll
that.
take your assurance, Madam.
I don't think prosecution I don't think prosecution is saying that he hasn't read.
Okay, very well.
document.
I take your assurance. Then let me therefore ask Mr. Gambit that what I understand the letter to be saying myself is that we have provided information from our records based on returns submitted by the Kenya Revenue Authority. Is not saying that what we are giving you is the document that was sent. They are saying we have a storage system and we have gathered from that storage system this information which we are sharing with you. I think that is clear, Madam President.
Thank you. I would now like to turn to the other subject matter, which has already been briefly discussed when Judge Fremer posed questions to Mr. Attorney General. But I would first like ask to prosecution whether when Judge Fremer posed questions consider that compulsory measures should have been or should be pursued by the Kenya to obtain the relevant records?
Well, the obvious example is the bank statements. We managed to get a partial agreement with the government of Kenya, receive bank statements of accounts in Mr. Kenyatta's own name for 3 months. Of course, we had originally asked for those statements for a longer period. Explain that the reason why is so that we between the period of time during the PEV and similar months in other years. And the court has approved that request and the 3-year period for which we have asked for bank statements. We have not received 3 years' worth of bank statements. Indeed, we have received no further bank statements following the decision of the Chamber confirming the validity of our request, which was issued on the 29th of July. So that's now over 2 months ago. Yes, certainly, we would submit that if those records could not be obtained by consent, then they should have been obtained compulsorily. The Kenyan government has, I am quite confident, powers to obtain bank records from financial institutions relating to people who are the suspects in criminal investigations. That must be the case domestically, and therefore it must apply to this case as well. There are, I dare say, other examples, but of course we are, if I can put it this way, somewhat stuck in the thickets of the argument between ourselves and the Kenyan government about matters like practicality of consulting the land registry or the company's registry. We are, if I can put it this way, somewhat stuck in the thickets of the argument between ourselves and the Kenyan government. Compulsion would be of no use, because one cannot compel the impossible. If on the other hand, Your Honours came to the conclusion that in fact there are alternative methods, let me stress, not unlawful methods or extrajudicial. I'm not talking about a Watergate break-in here. I'm talking about consulting government lists of telephone numbers. I'm talking about consulting registered office holders' interests, the sort of alternative approaches which have been widely canvassed both by the bench and by the prosecution. If Your Honours were to come to the conclusion that the Kenyan government has shown no desire and cannot explain its lack of desire to explore those alternatives, then compulsion would be appropriate.
Mr. Attorney General, has the Kenyan government taken any steps to compel the production of relevant records?
You know, where it has been possible within the law to carry out an independent interrogation of the requested subject, we have done so. And nothing better explains this than the letter from the governor of the central bank, which is contained in the filing we made on the 29th of August. It is very, very clear that the governor of the central bank has certain powers which the Minister of Lands doesn't have, which the Communication Authority doesn't have, and the governor has been able to use those powers, and he gave us information. So it is not true to say that in all situations where we received a request that we were unable to progress without consent. Not where we were able to doesn't have, and the governor has been able to use those powers, and he gave us information. So it is not the information.
So, Mr. Attorney General, you are saying that in this case, the Kenyan government, as far as the bank records concerned, has taken steps to compel the production of records, or not? Because my understanding from your submission is that the provision of bank records is on the basis of consent.
Yes?
So the
And-
Kenyan government hasn't taken any steps to compel the production of bank records. Am I right?
There has been no need to. The records relating to Mr. Kenyatta's bank accounts are available. They are before the court. There has been no need to take any other step in respect of that. In fact, the prosecution, Madam President, is not making such a case. The prosecution is making an entirely different one that we would have wanted for a longer period. They are not saying we have not received.
Yes, Mr. Attorney General, the prosecution wanted bank records for a certain period, which by this chamber's decision have been justified.
Then we negotiated with them for a period that we agreed on, and we provided that. You told us, go and negotiate in good faith to agree on a time frame that is reasonable. We did exactly that, and they got that material for that. If they are reopening the request and saying, now give us for 3 years, that would be a different matter.
Well, I think prosecution has been quite clear for its request for the bank records for 3 years, which this chamber already adjudicated that it's a proper request.
Well, I share that view, Madam President. We asked for 3 years. At the Chamber's behest, we entered
For its request for the bank records for 3 years, which this chamber already adjudicated that it's
about the other 33 months' worth to the Chamber. We did that. We argued it out. The Chamber issued a decision on the 29th of July, and the decision was in our favour, namely, that the full 3 years should be provided. In the 2 and nearly a half months since that time, those records have not been provided.
Mr. Attorney General, do you have any further comments on this?
The position remains as I have explained it.
Now I would like to turn defense. This specific point of consent. As we know of, I think it's 29th July this year, the provision of consent is of course a very helpful means of expediting execution of requests, although it may not be an adequate alternative in all circumstances. And moreover, the Chamber stresses at this point that the accused is not under any obligation to provide such consent. However, we understand that certain consents have already been voluntary in this case. And therefore, I have a couple of questions for our better understanding. First, is it correct that the defense was only approached to provide information or consent in relation to the request for vehicle records, bank records, and telephone records?
Madam President, first of all, on bank records, vehicle records, telephone records, those were...
And telephone records?
Madam disclosure because that has been a very sore point for the defence throughout this case, and I'm quite prepared to elaborate further on that, but I'm not sure it would be welcome by the court. Status.
Well, to the extent possible to the defense, I'd like information about the consent given by the accused. For example, if the consent, where the consent were provided, they were authorizing the provision of all relevant records under certain limited conditions. If you don't want to answer, that's fine. But if you can answer, please answer.
I'm quite happy to answer, because we have engaged in a regime of voluntary consent that started right at the confirmation of charges hearing and continued with that approach to this case. And we also entered into the regime of finding evidence of the case by going through a process of voluntary disclosure with the prosecution. It came to the stage of the case where the prosecutor admitted she had no evidence, and we came to that famous hearing where the prosecutor admitted his highly speculative lines of inquiry and about his case. In relation to that, we expected these charges to be dismissed. They weren't.
Mr. Kay, sorry to interrupt.
Where the prosecutor admitted his highly speculative lines of inquiry and about.
Mr. Kay, sorry to interrupt, but can you answer more directly to my question?
Yes, I notified consent for the months of December, January and February that were relevant to the case brought against us, that was relevant to the evidence that was relied upon, and not some. We disclosed that. They provided absolutely no support for the case, and I told the court that, but the court.
Mr. Kay, how are vehicle records?
Absolutely. We
the
gave,
same?
Yes. Our telephone record, a telephone number that the prosecution already had. That evidence, as this court has been reminded in filing after filing by us, was provided to the prosecution by the authorities in Kenya who run the mobile telephone networks, and they provided them with the evidence. As to providing any other telephone numbers, I haven't. I took the view that the approach to our cooperation in this case had been less than satisfactory, less credible for what we had done and what we had tried to achieve than we deserved. And so as a result of that, having looked at the relevant evidence as we knew this case to be, I decided no more evidence would be voluntarily disclosed by me. And that was a matter that I made as a decision because I felt the court was moving in the direction of a defendant having to prove his innocence. And that was certainly something raised this morning. And I know you have countered that by saying, of course, a defendant does. That I made as a decision because I felt the court was moving in the direction of a defendant having to prove his innocence. Whatever evidence we produced, further suddenly being requested, we need comparisons. I have never heard.
Mr. Kay,
spurious...
please confine your submission to my very specific question. Records. Have you already gives some consent
Yes, we
to disclose vehicle records.
Yes, we disclosed the vehicle records, and then the request became vehicles used by Mr. Kenyatta. But how on earth are we going to
Thank you very much, Mr. K.
document every vehicle he had a lift in? And that's what that request amounts.
Mr. K, is it possible for you, just for the completeness, of each of the consents?
I think you may have had those, but you've certainly had those in filings because you were appraised of various matters. I think they have already been disclosed.
Chamber hopes, if possible, you can have filing from the defense. That would help us
Yes, you've already
for the
had it.
completeness of the record.
Yeah, you've already had those letters, but we will certainly go back to that and provide you with the information.
Thank you very much.
Fact which the court was given, which had vehicle numbers, yes. So all this has been given.
Judge Henderson has some additional questions.
Okay, actually, Mr. K, it's actually not directed to you, so thank you very much. But no, the accused does not have to prove his case, so you can rest assured. It's actually to Honorable Attorney General. I'd like to ask you a few questions, please. The Attorney General. Yes. The to you, so thank you very much. But no, the accused does not have to prove his case, so you can rest assured. It's actually to Honorable Attorney General. I'd like to ask and to refer the matter to the ASP. Quite a serious allegation. And I agree with you that to make the finding, it is ready for you to persuade individually, collectively, by majority, that this is in fact the case. Case, in the sense that the subject of the complaint is actually a person who holds high constitutional authority. And the complaint perhaps is against the backdrop of this backdrop. And certainly I have the constitutional provisions, in particular Article 131D and 132. 131D, which is under the rubric President and Deputy President, and which has its side note, authority of the President. It provides that the President is the chairperson of the Security Council. So that's against that backdrop. Article 132, subarticle 5, which has as its side note functions of the President. It provides that the President shall ensure that the international obligations of the Republic are fulfilled through the relevant actions of the relevant cabinet secretaries. So putting that on one side, you have a situation where and it's quite an unusual case. The person who forms the subject of actions of the relevant cabinet secretaries. So putting that on one side, you have a situation where perhaps in a constitutional position. Is that a fair reading of the constitutional provisions?
Thank you, Judge. To know that you agree with me. Individual opinion of any lawyer before this court, no matter how learned, that will determine whether there has been cooperation or not. Issue determination by the court itself. I thank you for that. Secondly, and I'm coming to your question very shortly, I think I need to remind the Chamber with respect that the cooperation of the Kenya government with the ICC predates the election of Uhuru Kenyatta. Because
Yes.
sometimes that is forgotten.
No,
sometimes.
Mr. Attorney, I have a keen eye on the clock, so I know that, and we are mindful of your submissions, which we have heard in length on a previous occasion, and I recollect them quite clearly.
Yes.
So that I understand that. So perhaps if you could.
Yes, so then let me come to the second point. So that an argument that says the Kenya government is not working with the ICC because the office of head of state is fallacious. It is totally fallacious and baseless, because I personally was in contact with the prosecutor, with the registry, long before we held the election that brought the current administration to office. So let me leave that behind and come to the next point. There is an argument that there is a constitutional responsibility for the president to facilitate the enforcement of law. Generally, constitutional law.
Well, we're dealing specifically with the compliance with international obligations, of which this is the complaint. And what I would like to come specifically to is it something that perhaps is there on the face of it?
Generally, constitutional law.
Well, we're dealing specifically with the compliance with international obligations, of which this is
the ICC statute. The only other person in Kenya who to understand what our treaty is looks to the International Crimes Act. The Act identifies 3 focal points for cooperation with the court. The Minister for Foreign Affairs, the Minister for Internal Security, and the Attorney General. If, therefore, there is any misreading of the law, any administrative or any administration failure in cooperating with the court, then you must ask the foreign minister, you must ask the interior minister, you must ask the attorney general. That's one argument. The second argument, which is more fundamental, Judge, is this. This is an unusual case. Uhuru Kenyatta was charged before this court as a suspect before he took over the management of the Republic of Kenya. After he took over the management of the Republic, by dint of the same constitution, the president could not place himself in any circumstances where he would be deemed to have in any way impeded the impartial processing of this case.
All right. I don't want to cherry pick any of the specific requests, but what has come up from time to time this morning is the telephone records. So perhaps that might be a good one. So I'm not cherry picking, but I don't want to cherry pick any of the specific requests. Benefit of seeing the correspondence dated the 1st of September, as it came in, I think, after the last filing. From what I understand, it contains material in which the Telecommunications Authority indicates that they cannot act unless they are provoked by some court order. Is that correct?
Mm-hmm. Correct.
Now, the learned presiding, my sister, had indicated that she had asked a very specific question about formal steps being taken. Now, my recollection in an earlier hearing was that actually your complaint was that the prosecution could not just simply come to you and say, give me the keys for the barn and give me what you have, that they needed to come with a court order. And once you had, and that was unacceptable, but once it had basically the stamp of the court, then you could be moved on that basis to make such a request. Is that a fair recollection?
That is not actually accurate. And let me use the example of the other Kenya case, if I may, because it will explain this point very clearly. In the case, we came to the trial chamber. The trial chamber said there are witnesses who have refused to testify. Go and arrest them and bring them to the ICC. And I said to that chamber, I have no authority to do that. We cannot do that because we must do everything in accordance with Kenyan law as well. However, when the chamber finally said that these witnesses are compellable, I said to the chamber, I have no authority to do that. We cannot do that because we must do everything in accordance with Kenyan law as well. I am the one who provoked the request to the prosecutor. I said, give me the summons, ask the police to serve all the 8 people you say an election. Those who want to come will come. Then we will have no problem. You have no problem. Those who refuse, we will to a legal process. That's exactly what has happened. So, let's come back to telephones.
Yes, and when you are answering, because I'm too much time.
Okay.
But what yes, but what is, has been some anxiety here.
Because they have already...
Just a moment to tell you, is that here it is, you have the telecoms authority, here it is that it is a person is not somebody who you would have any difficulty in acquiring telephone numbers. Here it is where you have the telecommunication authority.
I must respectfully disagree.
Yes.
Because the letter from the communication authority says, and we have made this point before several times, before 2009...
I interrupt, my learned friend. I've got a copy of the letter here. The bench hasn't. It's crazy that you're relying upon my summary. Let me pass the letter up.
Yes, Mr.
Judge, the letter from the communication authority makes it very clear that there was no regime for the capture of information regarding subscribers during the period in question. Even if I had by some way or other an order that told me go to Airtel and Safaricom and get this record, they during the period in question. Even if I had by some way or other evidence that is not available. Let me give the prosecution has said security intelligence reports. We have come back on 2 occasions and said, these are the reports and this is what they say. There is no court order that can compel the intelligence service to issue a different report. So that is the end I can see. The cabinet said, give me these particulars and I'll conduct a search yesterday. Without these particulars, I can, even if there was a court order say, conduct a
Well,
search.
have you attempted to get a court order with respect to the telecommunications of September?
I beg your
The 1st of September, based on the letter. The letter says, I haven't seen the letter yet, but essentially the letter, it says that there's, okay, paragraph 2 says there's no regime for capturing the information. Paragraph 1, an order. So the question is, have you taken any steps, first of all, to inquire subsequent to receipt of this letter? It's a direct question.
I think I need to, yes. I need to, I think, refer you, Judge, to the 2 letters from the service providers, because I think that they...
We have those letters. Those letters indicated that
they are responding to me.
Okay, those from the court's recollection, those 2 letters indicated that they would require certain, the term of art I think is the MSISDN or the mobile.
I think that they...
We have those letters. Those letters indicated that
they are responding to me.
Okay, those from the court's recollection.
And that is why this is a circuit. This is, we keep going around, because I am told, can you get a court order? And I'm saying, even if hypothetically that were possible, what would the court be invited to compel Safaricom to do? Because Safaricom's answer would still be the same. Give me the mobile question, then I will search it.
So what you're saying
and
is...
the prosecutor says, I don't have the mobile number and have never had it. So...
It's that... Thank you, Mr. Taylor.
Thank you. Before giving the floor to Judge Fremer, Mr. Kay, about this consent, actually, I confirm that we have already certain materials which you disclosed, but we don't have your letters given to the authorities themselves. Is it possible for you to provide us with those letters of consent?
I'll make steps to trace the chain of documents.
Thank you very much.
Yes.
Judge Fremer.
Thank you for the floor. I have just a last question for Mr. Gumpert. Mr. Gumpert, at the beginning of this status conference, you called the situation before us, from your point of view, as a deadlock. So now, whether you retain your position or you see any way out?
No, it's still the prosecution's position that throughout the 2 hours of this status conference, there has been no indication from the representative. No, it's still the prosecution's material. And as long as that remains the case, I would respectfully submit. May I make one, I hope, helpful remark? Your Honours have seen one of Mr. Kay's consent letters. It is confidential Annex C to his filing 945. I can't speak to the others, but I was flipping through my papers and that occurred to me, and I thought that I could usefully say that in a non-partisan way.
Thank you.
May I have half a
So
second?
just my concern, maybe you should
Yes, thank
in
you.
interest of fairness,
Thank you,
to give
Judge.
chance to react.
I would like to respond to that by saying that it is totally untrue to suggest that we are deadlocked because the government of the Republic of Kenya is failing to do something. They offering many alternatives, including requesting, like we have done before, for the prosecution to give us actionable information, material that can help us to access. It is not true to suggest that these registries are inoperative, that they are non-functional. They are functioning registries. They require information. Please give us that information. We will supply whatever you need within 72 hours.
Thank you very much. And that brings us to the end of the matters to be addressed today. We have noted the submissions made and will take them into consideration in our decision making. We thank very much the parties and participants and the Mr. Attorney General in particular for their contribution. We have noted the submissions made and will take them into consideration in our decision making.
For a minute?
Yes.
At tomorrow's status conference, the representatives of the Kenya government have not been permitted entry. In our we are amicus in the case. We may be denied a right to speak or to make submissions, but I would very much request, Madam President, that we be permitted to be present.
Thank you, Mr. Attorney General, for the submission, but we have already made a decision. We have already made a decision, and that today's status conference, only parties and legal representatives will be invited. No amicus.
I think, Your Honour, may have misspoken.
Yes, tomorrow's status conference.
Thank you.
Yes, that's the end of this status conference today, and I would also thank before officers, interpreters, court reporters, and all other courtroom staff for their assistance today. The status conference is now closed, and the bench will rise.
All rise. We will